as well who have approached the Honorable Court to subside the proceedings that that has been initiated against them after SEBI's order declaring TPP as a CIS. The respondents in this particular case are Securities and Exchange Board of India, who has declared TPP as a CIS, State of Andhra Pradesh for the matters under issue number 2 challenging the constitutionality, and for the matter under issue number 3 for the quashment of FIR. The others placed in this particular respondent, the party includes those who have filed an FIR against Mr. Atul Verma. May the council state the brief facts of the case? Honorable Bench, this particular legal issue arises from the fact that Vadva Dairies Limited, an unlisted company, operated a dairy business plan which was for the sale of cattle and ghee, which was operated by a multi-level hierarchy network of agents. Honorable Bench, the Securities and Exchange Board of India received several complaints with respect to the same and initiated an inquiry. Thereafter, has declared that TBP qualifies as an unregistered CIS and has ordered winding up of Vadva Dairies Limited itself, and has initiated attachment proceedings along with ordering Vadva Dairies Limited to return the amounts along with interest. Honorable Bench, the agents have also been implicated by several investors. Agents in this particular case have also been implicated by several investors for several criminal provisions, and therefore the agents have created an organization called Pirit Agent Mukti Morcha and has approached this honorable forum to challenge the constitutionality of Section 6 of the Andhra Pradesh Nishpekshako ke Hitton ka Sanrakshana Adhiniyam 2000. If the bench is satisfied with the facts, may the council start the submissions for issue 1. Honorable Lordship, may the council deal with the issue right now only, the second issue first, and then take over the first issue? Or Honorable Bench, Section 6 of Andhra Pradesh Nishpekshako ke Hitton ka Sanrakshana Adhiniyam is as follows, titled as Punishment for Default by Financial Establishments. Clause 1 for the same says that where any financial establishment defaults any repayment of deposit on maturity along with benefits in the form of interest, bonus, profit, or in any other form as promised, or fails to render service as assured against the deposit, every person, including promoter, partner, director, manager, or any other person or an employee responsible for the management of or conducting of business or affairs of such financial establishment shall on conviction be punished with imprisonment for a term which may extend to 6 years and with a fine which may extend to 1 lakh rupees, and such financial establishment shall also be held liable for a fine which may extend to 1 lakh rupees. Honorable Bench, the major contention in this particular issue that is being raised is the very fact that the impugned provision conspicuously fails to consider the very essential requirement of Indian criminal jurisprudence, that is, an act does not make a man guilty unless his mind is guilty too. Honorable Bench, the establishment of mens rea along with actus reus is an essential condition to implicate any person under a criminal liability. Alongside, Honorable Bench, this impugned provision also treats different actors identically. For example, the directors having direct control of the management of funds and decision-making process are seen at par with the field-level agents working merely in an intermediary capacity. Your Lordship, this particular provision fails to consider the principle laid down by the Honorable Supreme Court in the case of National Textile Corporation versus Naresh Kumar Jagat, that Agents are merely extended hands of principal and they do not incur personal liability for acts done in the course of agency. Honorable Bench, this provision criminalizes all those several actors, namely promoters, directors, namely promoter, partner, director, manager, along with an open-ended phrase of other person or any employee. Honorable Bench, although there is a provision of any person being responsible for the management, however, the phrase "conduct of business" includes a wide range of actors working within any corporation or organization. With the due permission of the bench, the council would like to draw an analogy here. That let us assume that in a particular company there is a department concerned with the analysis of data. Therefore, the department is only concerned to analyze the data. However, does not have any proximate role in the other functionings or conduct of business of the company. However, if we see as per the language of this particular provision, those who were responsible for the conduct of the data analysis would also be held liable if this particular provision is to be imposed on that particular company. Honorable Bench, it was rightly established by the Honorable Supreme Court in the case of Shaira Banu versus Union of India that manifest arbitrariness is a violation of Article 14 and 21. This particular provision, along with being arbitrary, also fails the test of proportionality as was laid by the Honorable Supreme Court in Om Kumar versus Union of India, which is also may the council refer to the same, which is on page number 14 of the compendium. Honorable Bench, it is pertinent to bring before that as per the punishment prescribed under section number 24 of the SEBI's Act that punishes functioning of an unregistered CIS. The punishment prescribes goes up to 10 years with a fine of up to 25 crores. Honorable Bench, similar provisions, that is section 420 of IPC, that is cheating, section 406, that is criminal breach of trust, prescribes for a punishment that ranges up to 7 years and 10 years respectively. Therefore, Your Lordship, these particular provisions that do contain the valid provisions establishing mens rea and actus reus have been given the range of such higher level of punishment, wherein in this particular provision, section 6 of the Impugned Act does not establish any mens rea and also imposes liability on the mere assumption that every other person connected with the conduct of business of a company would be liable for a criminal liability under this particular section.
So you are addressing second issue.
Yes, Your Lordship.
So you are basically challenging the virus of section 6.
Yes, Your Lordship.
And that section 6 is of which adhiniyam?
Vindhya Pradesh Nishpekshako ka Sanrakshan Adhiniyam 2000.
So that is under the state jurisdiction or central jurisdiction?
Your Lordship, this particular provision is enacted by the state of Vindhya Pradesh. The council was about to address the same, that as per the list number, entry number 44 and 43 and 44 of the union list, this particular provision to regulate financial establishments and corporations other than banking companies.
Council, the question is whether you have made two respondents. Respondent number 1 is Union of India.
No, Your Lordship. Union of India is not a respondent in this particular case. Only state of Vindhya Pradesh, SEBI, and SEBI is the respondent. Honorable Lordship, that is petitioner memo, if you are referring to the same. That is, I'm sorry, that is the respondent.
Okay. So basically, can you enlighten this board on striking down of a particular provision and reading down of a particular provision? You want to struck off a particular provision or you want to read it down a particular provision?
Honorable Lordship, as this particular provision is ultra vires to the principle of ultra vires to the constitutional principles, being violative of Article 14 and 21 of the Constitution of India, the Constitution of Indica, the Council for Petitioner humbly pleads that this particular provision may be struck down for being ultra vires to the Constitution.
You just read one second. Section 6.
Lordship.
That you seek to be declared as ultravires.
Lordship. Where any financial establishment defaults any repayment of deposit on maturity along with any benefit in the form of interest, bonus, profit, or in any other form as promised or fails to render service as assured against the deposit, every person, including the promoter, partner, director, manager, or any other person or an employee responsible for the management or of conducting of business or affairs of such financial establishment shall on conviction be punished with imprisonment for a term which may extend to 6 years or with fine which may extend to 1 lakh rupees, and such financial establishment shall also be liable to fine which may extend to 1 lakh rupees.
What is wrong in it?
Honorable Bench, the over-inclusivity of this particular provision, imposing a blanket criminal liability on every person connected with a financial transaction or a financial establishment creates arbitrariness with respect to this particular provision, as it is a well-established principle of criminal jurisprudence that a criminal liability can only be imposed on a person for his own acts, inclusive of his mental ria to commit that particular offence, Your Lordship.
Now, as you read, it includes any other person.
Yes, Your Lordship.
It talks about any other person. So your why you are against that? Because he is collecting the name on behalf of the person and they acknowledge to the investor. So if that agent will not be included in any other person definition, then what kind of persons are included in that definition?
Honorable Lordship, in this particular provision, other persons refers to every person in the functioning or conduct of business. Herein, Your Lordship, as Your Lordship rightly pointed out, that the agent was merely promoting the particular scheme and was taking all those actions on behalf of the company. The agent was not acting in his own capacity, but in the capacity of agent of Varva Dairies Limited. Therefore, Your Lordship, without establishing his personal intent with respect to defrauding the investors or to default repayment, he cannot be held liable in this particular provision. And Your Lordship, this particular provision is not only challenged for the mere factual matters of this particular case. Your Lordship, this over-inclusive criminalization would also lead to further litigation in the near future to come, as this particular provision is over-inclusive and imposes criminal liability vicariously without even establishing the person's actual actus reus and mens rea. Yes, Your Lordship. May I ask if Your Lordship is referring to National Textile Corporation versus Naresh Kumar Brother? Honorable Bench, in this particular case, it was held that agents act merely as an extended hand of the principal and do not incur personal liability for acts done on behalf of the principal. Your Lordship, as the specific provisions in the Indian Contract Act also specify that agent makes principal liable for his acts done in the course of agency with due regard to the due diligence being utilized and taken care of.
So, according to you, that agent
is interest in contract with the company and collect on behalf of the company. Therefore, he is extended and hence is not liable for remuneration which has been done by the company.
Yes, Your Lordship. Yes, Your Lordship. The agent is acting merely in an intermediary capacity. He is a mere facilitator between the transaction, for the transaction happening between individual investors and the Vadwa Dairies Limited. Therefore, he should not be liable to incur personal criminal liabilities for the acts of the company, Your Lordship.
Who will be liable for the acts of the company? One line answer.
Your Lordship, as the company law provides that a company is a separate legal entity. The company is liable for its own acts.
Company is an artificial realistic person who will be liable.
Your Lordship, there is also a concept of lifting of corporate wheel.
I'm asking who will be liable. Which officer, which category of the officer or authority of the company?
Your Lordship, directors and promoters and all those in the managerial control or the decision-making roles shall be held liable.
All right. Is there any provision under Companies Act regarding that?
Honorable Bench, I would like to refer to the judgment in...
Not judgment. Is there any legal provision section?
Honorable Bench, may the counsel refer to the co-counsel for the same? May I
Please.
take 1 minute for the
Please.
same? Much obliged.
One more point which you have to address is that similar provision exists in MPID Act, which is of Maharashtra, and from Tamil Nadu Protection of Interest of Depositors Act. So similar provisions are there in those two acts also. And whether the challenge has been raised for that those provisions were also ultra virus, and if in those two state acts similar provisions exist, then what additional challenge can you put in this Vindhya Pradesh Act so that this is ultra virus?
Lordship, with respect to the question, the council would like to submit that in those particular provisions that is the Maharashtra and Tamil Nadu Act, the impugned section specifically referred to a mens rea. There were elements existing of mental element in that particular situation, which is absent in this particular impugned provision, Your Lordship. Therefore, there lies a difference between those acts and this particular act herein. Honorable Bench, with respect to your question of whether there exists any section or statute in the company law prescribing the same, so we'd like to refer to section number 149 that prescribes that the company should have a board of directors. Your Lordship, as rightly mentioned by Your Lordship itself, that company...
Behalf of a company.
Lordship, may I...
So even if this is a company and unregistered, the provisions of the company law are attracted, and you will have to look into the definition of officer in default who can be prosecuted. Let's see.
Lordship. Lordship, the particular provision is under clause section 2 clause 60, which prescribes that officer who is in default for the purpose of any provision in this act which enacts that an officer of the company who is default shall be liable to any penalty or punishment by way of imprisonment, fine, or otherwise means otherwise means any of the following officers of a company, namely whole-time directors, key managerial persons, where there is no key managerial person, such director or directors as specified by the board, and so on, Your Lordship.
This is the provision under which we can point out which authority can be prosecuted. Because a company cannot be punished. You can only impose penalty. आप कंपनी को जेल में नहीं डाल सकते.
Lordship.
Because it is on paper. It has existence only on papers.
So, don't you want to stress your arguments on section 40?
Honorable bench, the particular issue pertains only with respect to the constitutionality of section 6. However, the council would have raised contentions with respect to the same if the moot problem had allowed, and I also have a paucity of time. So I would request if the council may I have 2 minutes to conclude issue 1. Much obliged. Honorable bench, the first issue pertains to whether dairy business plan run by Wadhwa Dairies Limited constitutes as a collective investment scheme or not. Honorable bench, collective investment schemes definition is being provided under section 11 AA clause 2 of the SEBI's Act. The first condition pertains to the pooling of funds. Honorable bench, in this particular case, no pooling in of funds has been done by Wadhwa Dairies Limited. Rather, Wadhwa Dairies Limited has entered into individual bilateral contracts with the investors for sale of cattle or ghee. Therefore, Your Lordship, it cannot be held that all the money or the individual money that was taken in the form of consideration was pooled into one singular fund and was utilized for functioning of dairy business plan. The second condition pertains to the fact that the investors must have entered into the investment scheme with an intention to receive profit. Honorable bench, as per the landmark judgment in Balfour versus Balfour, to create a vinculum juris, that is a legally binding agreement, there needs to be an animus contrahendi, which generally arises from the fact that the parties would incur mutual benefit in the form of profits. Therefore, Your Lordship, the intention in the minds of subscribers while entering into this particular scheme was to acquire livestock and not incur monetary gains. Your Lordship, that leads us to the third condition, that the investment must form a part of the scheme and must be managed on behalf of investors. Honorable bench, the subject matter of the contract herein is the sale of cattle or ghee, alongside the service provided by Wadhwa Dairies post-contract for a 5-year period of nurturing of the cattle. Even though, Your Lordship, the cattle has been retained in possession by Wadhwa Dairies Limited, the investors exercise complete authority and control over the inspection rights, and the cattle is nurtured and reared as per their requirements, as is mentioned in the moot preposition as well. Honorable bench, therefore we can this also negates the fourth condition that says the absence of day-to-day control. Honorable bench, the cattle is reared as per the preferences or choices of investors of the subscribers in this particular case, and Wadhwa Dairies Limited is just a mere service provider acting on the directions and authority of the investors to rear and breed the cattle that they possess.
The investors are tangible aspect.
Yes, Your Lordship, the investors are investing in a tangible asset, that is cattle or ghee.
Thus, mere inspection, the word mere inspection is mentioned. So, mere inspection can be inferred as day-to-day control.
Honorable bench, in this particular situation, if we see, the subject matter of the contract is rearing of the cattle. Therefore, the day-to-day functioning of the scheme pertains to the same, the rearing of the cattle. And it is very clear, or it is evident that, Your Lordship, the cattle, being a sensitive creature, requires expertise to be nurtured. Therefore, Your Lordship, the term inspection here is with respect to the fact that the investors or the subscribers exercise control on how their cattle is nurtured. They have the control to see to inspect their cattle anytime. However, the experts of rearing and nurturing platform of Vadwa Dairy.
Council, probably you are not getting what we are asking is, inspection is a different thing and day-to-day control is a different thing. Like we as a judges, we are having control over the proceedings. They as a spectators are inspecting the proceedings. So whether merely inspection gives you a day-to-day control or not, that is the precise question which this bench is asking.
Honorable bench, the fact that inspection can be interpreted widely as well to include the possibility that that inspection includes the influential and decision-making rights as well. As was also mentioned that in this particular situation, the subject matter of the contract is the rearing of the cattle. The rearing of the cattle does not have anything to do on daily basis, Your Lordship. The broader aspect of the same is how the cattle is being nurtured. And that is under the complete control of the subscribers itself and not under the control of Vadwa Dairies Limited, Your Lordships.
Participation, that's the case of the company, not with the subscriber.
Basically, you are not giving a physical position of the cattle.
Lordship, the particular contract that the subscribers and Vadwa Dairies have entered into has this particular clause alongside sale. They also are they also have entered into a contract for service providing, that is rearing and nurturing of cattle in this particular case, and alongside as is the question of transfer of possession after the lapse of contract period, Your Lordship, that is 5 years in this particular situation.
You can skip the time.
In this particular situation, that is 5 years, after which the cattle is transferred in possession to the investors, and they are provided with an option that if they do not wish to take the delivery of the cattle, they can initiate the process for resale of the cattle.
Since you have mentioned a 5-year scheme, basically it's you are basically promising them 200% return over a period of 6 years.
Certainly, Lordship,
So if it's a 200% return or basically a fixed return, so whether it is an investment scheme or you are giving them a fixed return.
Your Lordship, this particular return that has been promised in here is with respect to the fact that cattle, we obtain milk from the cattle and make other dairy products out of the same, and that are sold in the open market.
Any particular case law by which you can substantiate your arguments?
Lordship, as per the case of PGF Limited versus Union of India, although that judgment is...
But in PGF it was relating to a plantation scheme, and in that plantation scheme physical possession was also being given. So that is distinguishable on facts. Here in the case in hand you are not giving them a physical possession. But in PGF they were giving a physical possession for plantation scheme.
Lordship, there's also this one particular case called Sudarshan Agro Farms Limited versus SEBI, wherein the facts also differ a little. In this particular case as well, there was a sale of land itself, the farmland or plot for farming or production.
However, in case of SEBI, you cannot rely upon because SEBI specifically debars guaranteeing any fixed return on investments.
Lordship, however, that particular provision that is contained in the SEBI's CIS regulations would not apply to Vadwa Dairies Limited as of now, as it is an unlisted company, Your Lordship. So we can say that SEBI does lack a jurisdictional control over Vadwa Dairies Limited, and the council would also like to contend here that.
So the question again is, if you are trying to escape the jaws of law that saying that it is an unlisted company, so whether unlisted companies are under the watch of SEBI or not?
Lordship, SEBI's regulatory jurisdiction has a wide scope indeed.
Because understand this thing. Sooner or later, you would be filing an DRHP, draft engineering prospectus, for getting it registered as an IPO. So, unless and until certain guidelines are being followed, SEBI would not be giving you a green signal for being listed as an listed company.
Your Lordship, however, the particular bar on providing guarantee which Your Lordship is talking about is on investment schemes. Your Lordship, dairy business plan is a sale agreement along with a service providing
Very well, that's
contract.
why we have specifically asked that since you are categorizing it as an, you are saying that it would only apply in an investment scheme. And you yourself are guaranteeing 200% returns for a period of 6 years. So it would come under the purview of investment scheme.
Your Lordship, the 200% return is after the lapse of contract period with respect to the same that the subscribers will be transferred the possession of a fully mature cattle, or if they do not wish to take the possession of the particular cattle, they
Read
would.
from your contract where you are promising them that you would transfer the possession. The basic question was that you have not promised them to transfer the possession.
Lordship, may I refer to the moot preposition?
Yes, please. Because transferring possession would include giving them the physical possession as well.
Lordship. May the council just take one moment.
You can take your time, others can address on this issue. The only point which you have to give is that you are giving them physical possession of the cattle fields.
Lordship, as per the para number 11, page number 3 of the moot preposition, point number 2, it says that page number 3, para number 11. Lordship, as per the moot problem. May I read the same, Your Lordship? Page number 3, para number 11, point number 2, which says that the dairy, where Varva Dairies Limited was engaged in the trading of cattle calf ghee. It had its own dairy farm to keep the cattle sold by it to the clients and to raise them up as per the client's requirement. Then, in the case client did, at the end of the contract period, the animal was handed over to the client. In case the client did not wish to take the delivery of the cattle, it was.
Counsel, you are referring to the handling over of animals, cattle.
Yes, Your
The
Honor.
specific question was physical possession of the cattle field.
Cattle field.
Yes. You have to show us that without giving them the physical possession of the cattle field, that was the sole point of distinguishing that judgment, EGF Limited judgment versus Union of India. In that judgment, a plantation scheme was there, and the physical allotment of that plantation scheme was given. And that's why we have asked a specific question that you are giving them the physical possession of the cattle field or not.
Lordship, the subject matter of this particular contract is the rearing of cattle, and therefore the transferring of possession of the cattle field, it is not coming to question here. The subject matter, the cattle or the ghee, is being transferred in possession to the investors after the lapse of contract period, Lordship. Lordship, due to paucity of time, if I have satisfied, may my co-counsel proceed
Yes,
further.
please.
It was truly an honor arguing before the honorable bench. Issue number 3 and 4 would be addressed by my co-counsel. Council seats.
Yes, yes.
May it please the Honorable Court, I appear on behalf of the petitioner and I shall address issue 3 and 4. If the bench allows, may I proceed with the issue 3? The Honorable Bench, the issue 3 talks about whether the FIR against Atul Verma should be quashed. It is most respectfully submitted, Your Honorable Bench, that the FIR against Atul Verma should be quashed as the dispute is purely civil in nature. The essential ingredient of the alleged criminal offence is absent, and the continuation of the criminal proceedings amounts to an abuse of the process of the law. Your Lordship, at the outset, the allegation in the FIR arises from the non-refund of money invested by certain subscribers under the daily business plan. The central grievance of the complainant is that the promised returns were not paid. However, it is a well-settled principle of criminal jurisprudence that mere breach of contract or failure to repay money does not amount to the offence of cheating under Section 420 of the IPC. The Honorable Supreme Court, in the case of Vidya Ranjan Prasad versus State of Bihar, which is given in the compendium on page number 16, clearly held that the offence of cheating under Section 420 of the Indian Penal Code requires the existence of fraudulent or dishonest intention at the very inception of the transaction, Your Lordship. The court categorically observed that a mere failure to keep a promise cannot give rise to a presumption of dishonest intention from the beginning. In the present matter, there is no allegation whatsoever that the petitioner possessed any fraudulent intention at the time the investor subscribed to the scheme, Your Honorable Bench. The FIR merely refers to the subsequent failure of the company to not repay the promised amount which was given under the daily business plan. Therefore, at its highest, the dispute relates to a commercial transaction rather than a criminal offence, Your Honorable Bench. Furthermore, the FIR also invokes Section 406 and 409 of the Indian Penal Code, which deals with criminal breach of trust. Your Honorable Bench, the most important ingredient of criminal breach of trust is entrustment of property. In the present case, the investors gave the money to the company, not to the agents. That means the property was entrusted to the company as it is a separate legal entity and has its own account. The agent neither possessed nor exercised dominion over the funds, Your Lordship. In the absence of entrustment, the offence of criminal breach of trust cannot be made out. This principle has been reaffirmed by the Supreme Court in the case of S.W. Palantikar versus State of Bihar, which is given in the compendium on page number 19, Your Honorable Bench, where the court held that if entrustment of property is absent, prosecution under Section 406 IPC cannot be sustained. It is further submitted, Your Honorable Bench, that the continuation of the criminal proceedings in the present case would amount to an abuse of the criminal justice process. The Honorable Supreme Court, in the case of State of Haryana versus Bhajan Lal, laid down authoritative principles governing the exercise of High Court under Section 482 and their inherent jurisdiction to quash criminal proceedings. The court identified.
For that, you have to make out your case that your case follows under those 7 principles which has been enunciated in the Bhajan case.
Agreed, Your Lordship, as given in the compendium on page number 16, Your Lordship. Your Lordship, you can find the categories on page number 22 of the compendium. Your Lordship, the first classification is where the allegation made in the first information report or the complaint, even if they are taken at the face value and accepted in their entirety, do not prima facie constitute any offence or make out a case against the accused. Your Lordship? No, Your Lordship, the moot proposition is silent, but the particular sections under which the FIR is filed is given under Para number 16 of the moot proposition, Your Lordship. Yes, Your Lordship. Your Lordship?
Now, starting filing FIR against the agents.
Your Lordship, the para number 16 states that in a frustrating situation, investors started filing FIR against the agent across various cities of the Union of Indica. On 2nd February 2018, Rani Malhotra, Jaya Saxena, Tejas Parmar lodged an FIR against one agent, Atul Verma, in Mediplus police station, Indra Prashad, Vindhya Pradesh, claiming 25 lakh rupees in total. FIR was registered under section 420, 406, 409, 120B, 467, 468, 471, 472, 34 of the Indian Penal Code, 1860, and Section 6 of the Vindhya Pradesh Nishpekshako ke Hitton ka Sanrakshan Adhiniyam 2000. Section 14 of the said Act bars the anticipatory bail, Your Lordship. So, Your Lordship, as it is given that.
So that bars anticipatory bail. And you are arguing for punishment of FIR.
Agreed, Your Lordship. But as also held in Anish Kumar versus State of Bihar, that preventing the ratio in the case was given that unnecessary arrest should be prevented at its highest, Your Lordship.
First, we can come down to the 7 principles that has been enunciated in Bhajan Lal's case.
Yes.
Now come to page 23 of your compilation.
Yes, Your Lordship.
You were reading first condition.
Yes, Your Lordship.
First condition was with respect to FIR.
Yes, Your Lordship.
FIR is not before us.
Agreed, Your Lordship.
So this point goes. Now come to the second point. That out of this, your case falls under this 7 provisions, and that's why FIR should not be registered against your client. You have to satisfy this bench on that point.
Your Lordship, as the sections were given in the para number 16, for example, if you take section 420, that is cheating. The most important ingredient of cheating is inducement. Your Lordship, I agree that the FIR is not given, but if we look at the bare act of 420, it is given that inducement have to be done with a bona fide intention. But in the present case, there is no certain allegation against the agent about the bona fide intention, Your Lordship. He was just an intermediary between the company and the subscribers, Your Lordship.
And that can only be come to a conclusion after evidence.
Agreed, Your Lordship. But as also according to the privity of contract, Your Lordship, only the parties to the contract can be held liable, Your Lordship. And in the present case, the parties to the contract is the company and the subscribers.
You are trying to say that anything which has been mentioned in the contract would be prevailing over the constitutional provisions or the legal provisions of IPC.
No, Your Lordship, I am certainly not.
And if there is a contract between two persons that, okay, I am giving a contract that you take this amount and you kill that person. And if any person registers an FIR against you, that, okay, there is you have committed a offense under section IPC. And you said, no, we are having a contract between both of us and he is giving me contract, therefore don't book me under any penal provisions. Can you take advantage of that contract?
Absolutely, no, Your Lordship. As also given under your example, that there was a contract of killing a person. That means there is a nullified intention. But here in the contract, it is a simple contractual obligation that is arising, and that is the non-repayment of the money, Your Lordship. There is no nullified intention from the part of the company also, Your Lordship.
Thing is, again, and try to understand this.
Yes, Your Lordship.
Whether or not there was a nullified intention or not would only be come to a conclusion after having witnesses, chief examination and cross examination. The first thing with this bench would see that prima facie FIR can be registered or not. If prima facie is a cognizable offense, then FIR has to be registered and further investigation and the national trial would be there. So you have to satisfy this bench that prima facie only the FIR should not be registered, and therefore this FIR has to be quashed.
Your Lordship, as I also stated that the FIR also
The FIR also contains section 406 and 409, that is entrustment of property, and the most essential ingredient is entrustment of property, your lordship. And in the present case, the entrustment of property was done to the company, your lordship, in its own account. The agent in the particular section, the quashment of FIR is about the agent, who is Atul Verma, your lordship. Also, your lordship, the FIR also contains 120B, which is criminal conspiracy, which include multiple persons. Here, the FIR is against only one person, that is Atul Verma, your lordship. So the ingredient of that also do not, and also your lord, yes, your lordship.
In the meantime, while you are advancing your arguments, tell your research team to go through the Niharika Infrastructure's judgment, 2021 SCC.
Okay, your lordship. Lordship, may I proceed with my lordship? Your lordship, the FIR proceeds on the assumption that since the petitioner acted as an agent of the company, he must automatically bear criminal liability because of the non-refundment of the money, your lordship. But however, criminal law does not allow vicarious liability unless expressly provided by the statute. Criminal liability is personal and must arise from the accused's own acts, accompanied by the requisite mens rea. In the absence of any specific allegation establishing such intent or conduct, the prosecution becomes a clear misuse of criminal law. Therefore, it is respectfully submitted that the dispute is essentially civil in nature, the essential ingredient of the alleged offence are absent, and the continuation of the FIR which amounts to an abuse of the process of the law. The lordship, if the bench is satisfied, may I move to the fourth issue? Your lordship, this fourth issue talks about whether agents can be held liable for repayment in the instant case. Your lordship, Vadvas Dairies Limited can be held personally liable for repayment of investors' funds under the Dairy Business Plan. It is humbly submitted that the agents cannot be held liable for repayment, and the contractual obligation existed only between the investors and the company. The company is a separate legal entity responsible for its own liabilities, and the petitioner acted merely as an agent within the scope of his authority. At the outset, the liability to repay amount arises from the contractual agreement entered into under the Dairy Business Plan. These agreements were executed between the investors and the Vadvas Dairies Limited. The deposit certificate, policy documents, and subscriptions form were all issued in the name of the subscribers by the company. Your Lordship, the Honorable Supreme Court in the case of NC Chaco versus State Bank of Vancouver held that a person who is not a party to a contract cannot be saddled with liabilities. Also, in the case of Della Pneumatic Tire and Selfridge Co., the House of Lords affirmed that contractual obligations bind only the contracting parties. Applying this principle to the present case, the petitioner, being a stranger to the contract between the company and the investors, cannot be held liable for repayment obligation arising out of that contract. Secondly, it is a well set up principle of company law that a company possesses a separate legal entity as distinct from its employees, shareholders, directors. This foundational doctrine was established in the landmark case of Salmon versus Salmon, your honorable bench, where the House of Lords held that once a company is incorporated, it becomes an independent legal entity capable of owning its own assets and responsible for its own liability. The company's debts and obligation remains those of the company itself and cannot automatically be transferred to individuals associated with it. In the present case, your lordship, the funds invested under the Dairy Business Plan were received by the Vadvas Dairies Limited. Also, the regulatory action taken by the Securities and Exchange Board also targeted the company's assets and properties, your honorable bench. This proves and demonstrates that the liability to repay the investors lies with the company and not to the agents, your lordship. Therefore, imposing personal liability upon the petitioner would effectively disregard the established doctrine of corporate personality, your lordship.
What about Section 233 of Contract Act?
Yes, your lordship. If you allow, can I take the Bear Act? The logic can I read the section? The rights of parties to a contract made by agents and not disclosed. The lordship, in the present case, the
Not disclosed means if you are not disclosing the current actual positions to the parties as an agent, then the personal liability of agents can also arise.
agreed, your lordship.
If you are not disclosing the true facts, like if any investment, if there is no certified agents of SEBI, and if any agent is not disclosing the correct financial position, it has taken some consideration from the client, then as per section 230 of contract act, his personal liability may arise.
Agreed, your lordship. Your lordship, first of all, in the present case, the principal is the company who has appointed the agent to work for it. And also the terms were clearly mentioned in subscription form, your lordship. So the undisclosed principal, the question of undisclosed principal did not arise in the present case, your lordship. As the principal was the company, your lordship. Can I proceed with the further argument, your lordship? The principal governing agency relationship under the Indian Contract Act makes it clear that an agent acting within the scope of his authority binds the principal and not himself. Section 212 and 211 and 12 of the Indian Contract Act provides that an agent must act according to the direction of the principals and exercise reasonable care and diligence in conducting the principal's business. However, the agent does not incur personal liability towards third party. In the present case, the petitioner acted solely as a field level agent who only facilitated communication between the company and the subscribers, your lordship. Therefore, it is respectfully submitted that the contractual obligations to repay investors rest solely with Vadavas Dairies Limited, the corporate entity that entered into the agreement and received the funds. The petitioner, being merely an agent who acted within the scope of his authority, cannot be saddled with personal repayment liability. Accordingly, this honorable court may be pleased to hold that the agents of Vadavas Dairies Limited cannot be held personally liable for repayment under the Dairy Business Plan.
Did the agent sign the agreement along with the company?
Your Lordship, the Moot proposition is silent upon that, but it can be pre-assumed that the signatory to the Dairy Business Plan was the company itself, and the agent was only the communicator of the Dairy Business Plan, Your Lordship.
Okay.
If the bench is satisfied, may the council move to the prayer. Therefore, may it please the Honorable Court of Indore Pradesh, in the light of facts and circumstances of the case, issues raised, arguments advanced, and authorities cited, the petitioner prays that this court may be briefed at judge, rule upon and determine the following. Declare the Dairy Business Plan of Vadavas Dairies Limited does not constitute a collective investment scheme under Section 11AA of the Securities and Exchange Code of India Act 1992. Set aside and restrain the enforcement of SEBI's order initiating attachment and recovery proceedings and stay the initiation of any further proceedings by the Ministry of Corporate Affairs against Vadavas Dairies Limited. Declare Section 6 of Indore Pradesh निष्पेक्षकों के हितों का संरक्षण अधिनियम 2000 unconstitutional for being arbitrary, vague, and violative of Article 14 and 21 of Constitution of India. Quash the impugned FIR and criminal proceeding against the petitioner, and hold that agents of Vadavas Dairies Limited cannot be held personally liable for repayment of investors' fund under the Dairy Business Plan, and or pass any order if may deem fit in the interest of justice, equity, and good conscience, all of which is most respectfully paid and submitted. It was an honor arguing before this honorable bench, Your Lordship.
What do you mean by this?
Your Lordship, sorry, Your Lordship.
Lifting of corporate veil.
Your Lordship, lifting of corporate, basically corporate veil is a wall that differentiates the responsibility of the company and the people behind it. So lifting of the corporate wheel is done in the cases where the mens rea of the company cannot be done, because as the company is a artificial person, so it cannot be led behind the bars, your lordship. So in the cases where there is a fraud on the part of the company, the corporate wheel is lifted, your lordship.
The person behind the act is to be looked into.
Yes, your lordship.
And can you connect it with the doctrine of Indore management?
Yes, your lordship.
How?
Your lordship, the doctrine of Indore management talks about that the outside third parties are not responsible for being aware of the internal management of the company. The company itself is responsible for managing its internal affairs and not the third party, your lordship. The bench is silent. Greetings to the Honorable Bench. The Council seeks permission to address the bench collectively as your lordships. Much obliged. The Council is here in the matter of Vadwa Dairies Limited and others versus Union of Indica and others on behalf of the respondents, that is Union of Indica and Sales and Exchange Board of Indica, SEBI. With due permission of the bench, the Council seeks permission to proceed with issue 1. Much obliged.
You are suit to client contention is based on issue number 1.
Yes, sir.
On behalf of Union of Indica,
Your Lordship, this
you are in which representative capacity?
in the capacity of SEBI.
So you would be only addressing or defending SEBI's thing, not Union of India. Indica.
Your Lordship, I will be representing Union of India for issue number 2. That is for the constitutional validity of section 6 of Vindhya Pradesh Nishpekshako Kendra Sanrakshan Adhiniam.
So whether Union, again the question which we have asked from them, now we are asking from you because your moot proposition is that whether council appearing on of Union of India can defend a state legislation.
Yes, Your Lordship.
Local like.
You are representing Union of Indica.
Yes, Your Lordship.
You are a central council, not the state council. There is a difference between central council and the state council.
Your Lordship, I'll be representing Union of India and SEBI for the issue 1, and then I'll be dealing with the issue 2 for the constitutionality of section 6 of Vindhya Pradesh Nishpekshako Kendra Sanrakshan Adhiniam.
Very well. So you
And that-
can address on issue 1, but in what capacity you would be defending issue 2?
Your Lordship, in the capacity of Union of India. So,
That's the very question. How Union of India can defend any act which has been made or drafted by state legislature?
One is Indian legislation,
yes, Your Lordship.
state legislation. That which is unselect is legislated by the
Union
state.
state legislature. Yes.
State is a different. Union is a different. How union is agreed by the state legislature or defending the state legislature? That is the question. You said that you are representing union and state, and who is going to represent the state?
How you means respondent side is in a position to raise any arguments in defense of issue number 2, that it is not ultra-virus, it is intra-virus.
Your Lordship, the Council please ignore this matter of fact. Your Lordship, the issue 1 deals with whether the DBP of Vadha's Dairy Limited constitutes a collective investment scheme under Section 11A of the SEBI Act 1992. Your Lordship, it is respectfully submitted that the dairy business plan squarely qualifies as a collective investment scheme within the meaning of Section 11A of the SEBI Act 1992, as the very first and foundational condition is that the contribution of payment made by investors should be with a view to receive profits, income, produce, or property stands clearly satisfied. Section 11A 2 mandates that investors must contribute monies with the objective of earning returns. In the present case, the participants subscribed under the DBP by depositing specified sums and were issued certificates acknowledging their participation. The scheme expressly represented that upon maturity, investors would receive 100% return on the amount contributed. Your Lordship, the Honorable Supreme Court in the case of PGF Limited versus Union of India held that where contributions are made by members of the public with expectations of profits, that is the 100% return, and the scheme is structured to generate returns, the first ingredient of Section 11A8 is satisfied. Now, applying this principle, the DBP mobilized funds from a large number of investors who were motivated by the promise of financial enhancement. Your Lordship, it is respectfully submitted that the second statutory condition under Section 11AA2 is that the contributions are pooled and utilized for the purpose of the scheme is also unequivocally satisfied in the present case. Your Lordship, please refer to the Moot proposition, page number 3. Page number 3, para 11, point number 5. It is stated that the amount taken from the customers was shown as advance from customers in the balance sheet. Your Lordship, this proves that there was no separate or identifiable accounts for each and every customer, and hence all the money taken from the customers were pooled into a single investment. Your Lordship, there is no material evidence to demonstrate that each investor funds were separately earmarked, ring-fenced, or exclusively tied to individual identifiable cattle maintained in isolation. Instead, the cattle were housed, managed, and commercialized collectively within the company's facilities. Also, Your Lordship, in the case of SEBI versus Gaurav Varshney, the Supreme Court dealt with a scheme where money was collected from investors under the guise of investment plans linked to assets, but the assets were neither individually identified nor separately earmarked for each contributor. The court held that when investor contributions are collected under a common scheme and the assets are not specifically identified or earmarked, and the enterprise is operated as a unified commercial activity and returns depend on overall scheme performance, then the arrangement satisfies the pooling requirement under Section 11A of the SEBI Act. The court clarified that physical commingling is not necessary, only the functional pooling, that is where funds are deployed in a common venture, that is the Wadhwas Dairy Limited, and investor fortunes are interlinked, is sufficient to constitute a collective investment scheme. Your Lordship, the Council further submits that the third statutory condition under Section 11AA of the SEBI Act, namely that the property, contribution, or investment forming the part of the scheme is managed on behalf of the investor, stands fully satisfied in the present case. Your Lordship, under the DBP, once the investors remitted the prescribed amounts, the entire responsibility of rearing the cattle, nurturing them, breeding, veterinary supervision, maintenance, and eventual sale of the cattle is vested exclusively with the company. The investors did not participate in the operational management of the cattle and the calves. They do not take participation relating to the procurement of feed, the selection of breeding cycles, the disease management, pricing strategy, or timing of sale. All such relevant activities which affects the economic returns were undertaken unilaterally by the company itself. Your Lordship, the Honorable Supreme Court in the case of PGF Limited versus Union of India held that where the scheme operator undertakes to manage the assets and generate returns for contributors, the requirement of management on behalf of investors is fulfilled. In the present case, the investors' role were confined to making contributions and awaiting the maturity of the policy. The day-to-day administration and commercial exploitation of the dairy assets were entirely within the company's domain. Your Lordship, it is further submitted that the fourth and final condition under Section 11AA2 of the SEBI Act 1992, namely that the investors did not have day-to-day control over the management and operation of the scheme, is also clearly satisfied in the present case. Your Lordship, under the DBP framework, the investors merely subscribed funds and were issued certificates. They had no authority to participate in the operational decisions concerning feeding schedules, the veterinary treatment, the breeding cycles, the sales timing, and even the pricing strategy or allocation of resources. The entire dairy enterprise was administered exclusively by the company, and any inspection rights, if provided, were merely supervisory or protective in nature and did not amount to full managerial control. Your Lordship, the Karnataka High Court in Medre Service Private Limited versus SEBI held that where investors merely contribute funds and the entire activity is carried out by the company without investor participation in operational decisions, the fourth ingredient of Section 11A is satisfied. The court clarified that theoretical ownership, right to visit the project site, or entitlement to eventual returns do not amount to day-to-day control, and the operational and managerial decision must rest with the investors to negate CIS classification.
Come to section 11AA, subsection 3.
Yes, Your Lordship.
Includes a list which provides an exclusion from CIS.
Yes, Your Lordship.
That includes schemes regulated by other laws. And if the petitioner's company is registered under sales tax department, and if sales tax department is supervising their conduct, so whether SEBI authorities can overlap the jurisdiction of sales tax department and poke a nose into day-to-day affairs of that company.
Your Lordship, the SEBI is registered.
That company is not having their own IPO registered because they are unregistered. They have yet to draft their DRHP.
Your Lordship, the company is registered under the Companies Act itself, and it is just an unlisted company. Your Lordship, it satisfies this condition that it is not registered any other arrangement of the central government.
You being a specialized agency, there has to be a distinction between listed company and unlisted company.
Yes, Your Lordship.
So what advantages and what disadvantages are there for a company to get listed and under the SEBI laws?
Your Lordship, if a company is listed under the SEBI Act, it has the right to issue, it has the right to get public, issue prospectus and get funds from the public. Whereas an unlisted company does not have the right
It is
to.
not financial point of view.
Yes,
But as soon as a company get listed under the SEBI or they are having a listed company, then checks and measures are there.
yes, Your Lordship.
They have to publish their result quarterly. They have to do all things. So that's why, if at all the money is they want to advance money from the public, then only any person wishes to incorporate any company wishes to get themselves listed. Otherwise, not, because of the checks and measures that has been put by the SEBI.
Yes, Your Lordship.
At this point of time, their company is an unlisted company.
Yes, Your Lordship.
They are under the guidance. They are under the direct supervision of sales tax department. So how SEBI can invoke their nose and get in the affairs of the company which has already been regulated by the sales tax department?
Your Lordship, answering to that question, Your Lordship, under 11C of the SEBI.
Vis-a-vis section 11AA subsection 3. Advance your arguments on that.
Your Lordship, according to Section 11C of the SEBI Act, SEBI is empowered to conduct investigation where the board has reasonable grounds to believe that the transaction in securities are being dealt with in a manner detrimental to the investors or to the securities market, or any intermediary or any person associated with the securities market has violated any of the provisions of this act or the rules or the regulations made or directions issued by the board.
Yes, so the word mentions are in the securities market. Read again the provision.
Yes, Your Lordship. The transactions in securities are being dealt with in a manner detrimental to the investors
Yes, read further.
or,
Read the provision.
or to the securities market.
So the word is securities market. There is an unlisted company, so there is no security market.
But Your Lordship, SEBI received significant complaints from the investors as per this section, and on the basis of those complaints, SEBI initiated an investigation.
In your defense, you have mentioned that if any complaint is being received by a SEBI, then it is under the scope. There is a separate mechanism for complaints that is under the scope. So any complaint, have you mentioned that there is at least 7 complaints registered under the scope? Because you are having a designated mechanism for complaints that has been received by SEBI.
Yes, Your Lordship. Your Lordship, in page number 1, para 6, it's given that the Security and Exchange Board of India is a statutory body set up to protect the interest of investors and regulate security market in Indica. SEBI received investor complaints against Wadhwa's diary alleging that it was operating schemes plans without being registered with SEBI from the deposit certificate and first installment received enclosed with the investor complaints. So SEBI did receive investor complaints, so that should. With due permission of the bench, the council seeks permission to proceed with issue 2. The issue 2 deals with whether section 6 of the Vindhya Pradesh Nikshepako ke Hiton ka Sanrakshan Adhiniyam 2000 is constitutionally valid. It is most humbly submitted that every legislative in Your Lordship, I can deal with issue. The other council will be dealing with issues 3 and 4, but I'll be dealing with this issue in the. I'll deal with this issue in this capacity of state legislature. The section 6 of the Vindhya Pradesh Nikshepako ke Hiton ka Sanrakshan Adhiniyam imposes criminal liability on financial establishments that default in repayment of deposits or fail to provide promised returns or services. The core objective of this provision is the protection of depositors who entrust their savings to financial establishments. Your Lordship, the constitutional validity of similar legislation was affirmed by the Supreme Court of India in the case of K.K. Bhaskaran versus State of Tamil Nadu. In this case, the court upheld the validity of the Tamil Nadu Protection of Interest of Depositors Act 1997, which had been enacted to protect the depositors from fraudulent financial establishments. The court observed that deposit schemes often involve the collection of money from public from thousands of individuals, and ordinary legal remedies are frequently ineffective or slow in providing relief to the depositors. Your Lordship, thus Section 6 advances a legitimate legislative objective of protecting depositors and preventing financial fraud and therefore cannot be considered unconstitutional. Further, Your Lordship, Section 6 extends the criminal liability not only to the financial establishment itself, but also to the promoters, partners, directors, managers, and any other person responsible for the management or conduct of the business of the establishment.
Also, just a small query from our side. If we propose from this bench that if this court finds that section 6 is a partially unconstitutional, and that instead of striking down the provision completely, we just are in our opinion to read down the provision so far as agents are concerned. So you are considering only that issue, or you would still harp upon the fact that no, it is an intra-virus and even the reading down is not permissible.
Your Lordship, the reading down of that specific provision.
You would be facing a risk that we may arrive at a conclusion that it is unconstitutional and we may declare this law as ultra-virus. So facing the situation, you are having two choices in your hand. First is that you concede that okay, it is a partial and unconstitutional, and instead of striking down, this bench may proceed and declare it as a read down provision. Or if you advance your argument at this point of time, then we may not come to a conclusion and we may strike down this provision as well. So we want a precise answer from your point on this.
Your Lordship, I would like to continue with my submissions. Your Lordship.
Is the risk that we may declare this law as ultra-virus?
Yes, Your Lordship.
Very good.
Your Lordship, if the liability is imposed solely on the corporate entity, individuals responsible for the fraudulent conduct could escape accountability by hiding behind the corporate structure. Your Lordship, the necessity of strong regulatory control over the schemes involving public funds was also recognized by the Supreme Court of India in Sahara India Real Estate Corporation Limited versus SEBI, where the court held that the authority of regulatory bodies to intervene and impose strict measures against investment schemes that involve large collection of public funds. Your Lordship, this particular section, it also imposes liability on agents and other persons because agents too are involved in inducing the investors to purchase the scheme. If there was no such inducement on the part of the agents, the investors would not have subscribed to the scheme and would not have lost their hard-earned money. Your Lordship, further, Section 6 does not violate Article 14 because it is based on reasonable classification that bears a direct nexus with the objective of the legislation. Your Lordship, the provision applies specifically to financial establishment that accepts deposits from the public and subsequently default in repayment. Such entities form a distinct class because they deal directly with public savings and hold funds belonging to a large number of individuals. Therefore, the legislature has intentionally targeted these kind of establishments that collect deposits from the public because these entities pose a unique risk to economic stability and public confidence in financial markets.
So since you were willing to take the risk that we may come to the conclusion, now we can directly come on the judgment point. So you may have gone through the judgment of Nikesh Tarachan Shah versus Union of India, in which section 45 of PMLA was declared as ultra virus.
Yes, Your Lordship.
How do you distinguish that provision from section 14 of this act?
So, Lordship, the Section 6 of this Act,
Targeted related to anticipatory bail.
Your Lordship, the petitioners have challenged only sections, validity of only Section 6 of Andhra Pradesh Nikshepako ke Hitton ka Sanrakshan Adhikam, not Section 14 of the anticipatory bail, because there are multiple legislation excepts which bars anticipatory bail. For example, Your Lordship, Section 18 of the
So for
SC
that you have to argue that doctrine of severability would apply and section 6 and section 14 cannot be read conjointly.
Yes,
Whether
yes.
this you are trying to say?
Yes, Your Lordship,
Now
because
read section 6 and then read section 14. And demonstrate before us that those two provisions are not in relation with each other.
Your Lordship, Section 6 states that whether any financial establishment defaults any repayment of deposit on maturity along with any benefit in the form, bonus, profit, or in any other form as promised or fails to render service as assured against the deposit, every person, including the promoter, partner, director, manager, or any other person or an employee responsible for the management or conduction of the business or affairs of such financial establishment shall, on conviction, be punished with imprisonment for a term which may extend to 6 years and with fine which may extend to 1 lakh rupees, and such financial establishment shall also be liable to fine which may extend to 1 lakh rupees. Provided that, except for special and adequate reasons to be recorded, the imprisonment shall not be less than for 1 year and fine shall not be less than 50,000 rupees.
Here for the date, either in the capacity of a manager or a director, or he is not at all involved in the day-to-day affair of the management of the company. But the word we have to use is management. How he is involved in the day-to-day affair of the management of the company.
See, company can be held responsible. How that agent can be held responsible under section 6? First question and second question was answered sir's question query. Then also answer section 14.
Your Lordship, the Council seeks an extension. Your Lordship, Section 6 says that any other person or an employee responsible for the management or for the conduction of the business or affairs of such financial establishment. Your Lordship, the schemes were brought to the company on a day-to-day basis by the investors through a pyramidal structure. There, under Annexure A, the terms of agreement between Vadhwas Dairies Limited and 1,48,000 investors has been attached, and also the pyramidal scheme and contract of employment for its 12,000 agents and commission allocation scheme has been attached. Therefore, Your Lordship, the agents were paid on a basis when they brought further agents and the investors who would subscribe to the scheme. Hence, by they are inducing the investors to subscribe to the scheme and are involved in the conduction of the business.
But as per the report, as many as 847 agents have committed suicide.
Yes, Your Lordship.
So there has to be a humanitarian consideration in ground.
Yes, Your Lordship.
So that's why we have asked specifically that with respect to promoters and with respect to agents, whether there can be two different sets.
Now you have to differentiate because there's a question of
Intelligible differentiation.
So the question is that very well we are in a consensus that with respect to company section 6 applies. But you have to satisfy this bench that with respect to section 6, the word agent, and so as per record, 847 agents have committed suicide. So because of this provision, when they are not in a position to gain everything and lose everything, can this section 6 survive with respect to agent?
Your Lordship, the section 211 of the Indian Contract Act, Your Lordship, it says that an agent is bound to act according to the directions of the principal. The principal here is the promoters and the directors. And why I am involving Indian Contract Act is merely because in Annexure A, the company itself has filed the contract of employment for its
Council, try to understand this. In penal law, there are various types of punishment, deterrent punishment, and all other things. If there is a case of culpable homicide is going on, or if a case of murder is going on, then it is a tribal. Then it is tribal by.
Your Lordship, if it's a case of.
If it is a punishment of more than 7 years, then it would go before
The Sessions Court.
Sessions Court. But if a person has abused another person, or if he has slapped another person, then it would go before GNLC, class 1 or class 2. So there has to be a difference. So whether agent can come into the footsteps of principal, or whether an agent can come into the footsteps of promoters, and they both can be held liable for the same amount of punishment. No promoter has ever committed suicide. Any of the promoter of this Vatma company has not done anything. Who is suffering because of this act or because of this section is those 847 agents. So we are specifically on those 847 agents.
Your Lordship, there was a common intention on part of the agents as well on the part of the promoters to falsely induce the investors into the scheme. Thereby, we are prosecuting the agents as well as the.
He is bound by the directions of the company. Then, if the agent is bound by the directions of the company, then how he has been held responsible for the act which is done by the company. But whatever he has done on the instructions of the company, not his own. So, whether it amounts to a conspiracy.
There has to be accountability. We are not denying on that. But accountability would be only with respect to the company. How you are implicating agents for such a severe punishment under section 6?
Because act has been done by the company.
Because there is
acting upon the instructions of the company.
And because there is a complete bar on anticipatory bail under section 14. So as soon as section 6 is invoked, they are remediless. They are put behind the bars by good agencies of your court. And they are not having a shelter of bail also under anticipatory bail under section 14. So they are left with no other option except to commit suicide. Because even if they are acquitted after 6 years or 7 years of trial, then major portion of their life is behind the bars. So they are left with no other option. So satisfy this court with respect to agents. We are in a consensus that okay, you put the promoters behind the bars. We are not having any problem with it. But why those agents?
Your Lordship, because the agents, just like the promoters.
Therefore, you have specifically asked that we would try to read down the provisions so far as agent, and whether you are willing to take the risk of striking down of that provision completely, or you in a position to concede that okay, with respect to agent, we are conceding that you should read down, and with respect to promoter, this provision is intravenous.
Entire money has gone to the coffers of the company. Agent has got nothing except committing suicide.
Your Lordship, the agents were Your Lordship, just like the promoters and the directors of the company, how they were in the favor of attracting more and more investors to the CIS so that more and more funds could be mobilized. And
That looks good while hearing only.
Your Lordship.
You'll have to satisfy. There are rights and obligations between the company and the agent. You'll have to examine that.
You have to understand one thing. Act as an officer of the court, not defend every action of the state or the union. Getting it?
Yes, sir.
As an institutional lawyer, you are not fighting this case in a personal capacity like the
Other
company.
parties will.
You are an officer of the court under SEBI, or even if you are representing Union of India. So it's not you would not gain anything or any negative marks for this or any positive marks for this. But just we are trying to explain that when you are representing an institution, then you have to judge the mood of the court. That okay, from if we are harping upon this argument, then our entire things goes.
Your Lordship, the council submits to read down that provision in respect of the promoter.
The next one.
If you had considered that thing at the first instant itself, then all their arguments would have been gone.
Yes, Your Lordship.
Because you are in position to save your own state.
And then
That is the
you could have amended the statute and make an amendment and create another section with respect to liability of agent, which would not be as harsh as this section 6, but that would be holding them accountable if they have done anything. So that is the best way which you can save your skin also, and you can protect section 6 also.
Yes, Your Lordship. Yes, Your Lordship. Thank you, Your Lordship. Thank you, Your Lordship. It was a pleasure arguing with you.
Like your confidence when you have said that okay, we are in a position to argue.
The council seeks permission to proceed with issue number 3. Issue number 3 particularly deals with whether FIR against Atul Verma ought to be quashed. It is humbly submitted before the Honorable High Court of Andhra Pradesh that the FIR against Atul Verma ought not to be quashed. The reason there is that there is a prima facie evidence that suggests his involvement in the fraudulent scheme. Particularly, I request the Honorable Bench to look into the memorial, Section 6, which is given in the Annexure B of the Andhra Pradesh Nikesh Pako ke Hito ke Sanrakshan Adhiniyam 2000, which explicitly mentions any person. And while mentioning any person, it also includes the person like agent. Particularly, it mentions who are working in the management and the conduction of the work. And here, agents were not holding any directional position, but they were instrumental to the growth of the establishment. Your Lordship, here DVP's very structure is based on pyramidal structure. Now, pyramidal structure is what? Where the agents are recruited in order to recruit more agents, and as well as selling the scheme. So here they're not just getting the commission only on the basis of selling the scheme, but also for recruiting the other agents as well.
So basically, they have not raised this point, but please read section 6, subsection 2 of VP Act.
Indeed, Your Lordship. No police official shall investigate an offence under this Act without express permission of officer not below the rank of superintendent of
Yes, so
police.
the thing is, whether you have made out your case that the investigation, qua the complaint more than 25 lakh rupees was done by SP or his IS officials. Because if it is not being done by, then it lacks the jurisdiction and the competency, and the entire FIR goes. Whether you have mentioned this fact that this entire investigation has been done by SP or his superior officials. In your entire memorandum, we have not found this thing. Because you all very well know that in terms of criminal jurisprudence, the burden of proof, the onus lies upon prosecution. So therefore, we are not raising this question from you, we are raising this question from the prosecution.
Indeed, Your Lordship. Lordship, on this fact, the memorial is silent that whether the investigation has been done by.
If the memorial is silent and you have also not done anything, then it is a classic case of defective investigation, and the FIR goes.
But Your Lordship, then FIR will be registered after that the investigation process and everything will be carried
It
out.
would have been done in a fresh FIR. So far as this FIR is concerned, that FIR goes because it is not being done by the competent person. Therefore, I have straight away asked for reading of section 6, subsection 2.
Clearly, the entire investigation goes the entire trial moves, then nothing survives.
Classic case of defective trial.
Your Lordship, on this regard, I would like to state out a case of Essence Sheshagiri versus State of Andhra Pradesh, where the Honorable Supreme Court observed that the High Court should be extremely cautious and slow to interfere with the investigation and trial of the criminal cases.
But investigation has to be proper.
But the competent
Cite any case law in the entire history of this India that whether we cannot interfere a case when investigation has been done by the incompetent authority, and then also the court's hands are tied and we cannot interfere in the defective investigation, and we are not in a position to pay the FIR. Cite any case law.
Your Lordship, the counsel not mentioned the state law as it is the moot problem is particularly decided on who investigated like which officer has been given the authority to investigate.
Very well, but you are not arguing a case of a civil nature. You are arguing a case of criminal nature. And the first and foremost thing is the burden lies on prosecution.
Yeah.
So, before establishing your case or before preparing your memorial, one has to read section 6 subsection 2, and one must carefully ought to have been noticed this fact that in your reply to the moot preposition that the investigation has been done by the person SP or above his rank. Otherwise, this case is thrown out of the window because of the competent jurisdiction.
The counsel please ignore it for this one. Shall I proceed?
So now, what you would be arguing?
On the basis of the provide
The only scenario left in front of you is that you are having no option except to make us clear that a fresh FIR has to be registered against them by the competent authority, and then you would be in a position to proceed the case. And for that, you have to seek liberty from us that okay, fresh FIR needs to be registered against the offender.
and the FIR, quite the entire investigation. You are required to see the fresh from this initial stage of investigation. So your FIR will survive, but entire investigation and everything goes.
So, Your Lordship, the FIR, the counsel seeks permission that FIR is to be there, and after that, the investigation.
To concede that okay, that investigation was defective, now we have to start afresh after registration of FIR, and then the investigation would be done only by the SP or competent authority.
Indeed, Your Lordship.
So question 3 goes. Issue number 3 goes. Now come to issue number 4.
This is totally a reverse thing. What usually happens, would always protect the prosecution.
He as a solicitor general and I as an additional advocate general would always be on side of respondent. But then too there is a classic case of mistrial.
Okay. I hope so you understood the point.
Indeed, Your Lordship. Shall I proceed with issue number 4? Issue number 4 particularly states that whether the agents can be held liable for the repayment in the instant case. It is most humbly submitted before the Honorable Court that agents, including the petitioner, cannot be exonerated from the liability to repay the outstanding dues. They serve as an operational backbone of an unauthorized financial enterprise, and their role transacted that of a mere employees, that is positioning them as an active facilitators and beneficiaries of a predatory scheme. Your Lordship, the respondent contends that the daily business plan, that is the DBP, was meticulously designed on a basis of the pyramidal scheme that basically works on the agricultural ventures.
But whether issue number 4 is with respect to only liability of agents.
Liability for the repayment, and particularly issue number 3, we dealt with only Atul Verma.
Issue number 4 is with respect to repayment on behalf of agents, and your co-counsel has already considered that okay, this provision shall be partial struck down, and agent part we are considering. So if that provision is read down and agents are not included under section 6, then how this repayment can be, the liability of repayment can be fastened upon agents?
Your Lordship, the liability that is to be protected of agent, particularly is based on the I'm contending on the basis of the pyramidal structure.
Co-counsel is already considered that agent has to be excluded.
But Your Lordship, we can give the liability on the agent on the basis of section 211 itself also, because of the fact.
So you are not insisting upon section 6.
I'm not insisting
Because repayment was on the basis of section 6 or on the basis of section 211.
Your Lordship, repayment generally dealt with that whether the agent can be held liable for the repayment in the instance.
That's the precise question, counsel. That when your co-counsel is already considered with respect to agent, that the provision shall be struck down, read down, sorry, then how you can fasten the liability? At best, you can say that okay, we would be asking for repayment from promoters or from the company, not from the agent.
The council would like to light on certain things that when we firstly in respect of issue 3 as well, that firstly when the FIR was registered and after things have happened, that means the investigation was not nullified at that, and then the charges have
Not nullified, we are on the competence of jurisdiction. There are two things. One, that I am having a grudge on a particular person and nullifiedly I have issued a FIR. And second, that I am a peon, I am not even a IPS officer and I have issued an FIR. So that is the jurisdiction. You must understand the difference between jurisdiction issue and nullified intention.
but
So now in our opinion, the skin of respondent can be saved only by the closing statements. That what closing statements you are in a position to give after judging the attitude of this bench. So you can have a minute or two, you can discuss it among themselves, and we want an appropriate closing statement on side of respondent.
Your Lordship, particularly want to state out that in para 16, it was held that in a frustrating situation, investors started filing FIR against the agents across various.
Again, agents, counsel.
I just.
But the thing is, agents, when your co-counsel have already considered with respect to agents, then how you can rely upon those judgments?
Lordship,
The only escape you can have from this court is what closing statements you all are giving.
Your Lordship,
Sometimes if you want to stretch the arguments, then instead of saving, you may damage everything.
Your Lordship.
So the closing statements on behalf of statement is of utmost importance. What closing statements you want to give?
Your Lordship, the council
Take
would
deep
give
breath,
the
have a sip
closing
or two, discuss it with your fellow counsels and give a closing statement.
समोसा से पका के रखे हुए बार बार मिलाएंगे और एक ही कैमरा से मिलाएंगे।
With the due permission of the bench, the council seeks permission to proceed with the prayer. Wherefore, in the lights of the past stated, issues raised, and arguments advanced and authority cited, the respondent humbly prays before the Honorable Court that will be pleased to uphold the SEBI order and declare the GBP as a collective investment scheme. The council pleads that the liability to be brought primarily to the promoters and the directors, and according to the section 6, declare it unconstitutional only in respect of the agent and to be read down, and not in the respect of the promoters. And lastly, and the directors to be paid of the entire liability of the to the investors. And any other order that the Honorable High Court may be pleased to pass in the respect of justice in the investors.
Question from our side.
थोड़ा सा बस 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 अरे ये नहीं घुमाना है किसको घुमाना है डंडा निकल रहा है।
However, we have certain conditions that were not taken.
If you are going to get something, they have already considered. That's why you are going for the matter. It is not required. Already.
ये क्यों टाइप दिखा रहे हैं दिखाएंगे प्रेजेंट तक दिखाओगे आध घंटे बाद घंटे थोड़ी देर पॉज तो कर दो पॉज नहीं होता लाइव बाहर सेटअप कर सकते हो क्या अभी कुछ वो 15-20 मिनट है 15 मिनट तो कर सकते हो क्या ऐसे उठा के ले जाते हैं कोई जजमेंट के बिना लाइव कैंसिल नहीं हो पाएगा लाइव हो जाए अरे चीज लाइव को ऐसा ही होगा उठा के पोडियम से बाहर रख सकते हैं क्या 15 मिनट लाइव करने के लिए एड्रेस चेंज हो जाएगा आईपी चेंज हो जाएगा तो कितनी देर लगेगी कोशिश कर लो तुम तो फटाफट से जल्दी कर सकते हो 15 मिनट का कितना बार कितनी देर चलेगा उधर 1-1.5 घंटा अगर कर सकते हो 15 मिनट तो कर लो अच्छा लगेगा बाहर का वैलिडिटी कवर हो जाए चलो तुरंत हाईकोर्ट जाके बैठे अंदर आओ उनको रोक रखा है अपन ने दबा क्या इसको बंद करने में क्या कर रहे हो कौन सा कहां जा रहा तू अरे बैटरी डिस्चार्ज हो जाएगी कहां जा रहा मैं चार्ज करके दे दूंगा एक पैसा नहीं कहूंगा 1 रुपया नहीं लूंगा फ्री में करके दे दूंगा अरे